Good morning. I'm attorney Gary Finklea from the Finklea Law Firm in Florence, South Carolina. Oftentimes we represent folks involved in accidents whose injuries are aggravated. In other words, they had a pre-existing condition and it is either symptomatic or either asymptomatic, and due to the accident the condition got worse. Clients in those situations often wonder whether or not they can recover, and the answer is yes. Even though the answer is a simple yes, proving the level of proof that we need to in these types of cases are very difficult. First, let me share with you a little bit what the law says in regard to aggravation of a pre-existing condition. And what I'm going to do is actually just read out of one of our requests to charge books, and this was penned by Judge Anderson here in Florence, who I clerk with. An injured person is entitled to recover all damages caused by the defendant's negligence. When plaintiff's pre-existing physical or mental condition is aggravated or activated by a subsequent act, the defendant is liable to the extent that his wrongful act proximately and naturally aggravated or activated plaintiff's pre-existing condition. A defendant who causes injuries to the plaintiff with a pre-existing condition must take the plaintiff as we find him. Although not responsible for the pre-existing condition itself, the defendant is liable for any exacerbation of it caused by his tortious conduct. We often call this the thin skull plaintiff theories. In other words, as the charge indicates, the defendant takes the plaintiff as he finds him. So oftentimes what we find is folks had a pre-existing back injury. Maybe they had an actual injury, maybe it was just an arthritic condition that was asymptomatic. In other words, they had it previously, but it was under control. Wasn't in a great deal of the plaintiff wasn't in a great deal of pain. Then the accident comes along and makes it a whole lot worse. It begins to hurt. The plaintiff requires treatment. And so what this charge says and what the law says is that even though we can't hold the defendant responsible for causing the initial problems with the back, we can of course charge the defendant responsible with aggravating the pre-existing condition, paying for all the treatment due to that. Now, that's an easy case where a plaintiff isn't undergoing any treatment at the time of the accident and hasn't for some time. The more difficult cases arise, however, when a plaintiff is actually currently receiving treatment, then has the accident and has to receive more treatment. These types of cases are very difficult because it all depends upon the level of proof that we're able to establish. You know, how does a jury distinguish between what medical bills and injuries the plaintiff would have received anyway, as compared to what medical bills are due to the accident. So it is a very difficult type of level of proof. It often depends upon the detail of doctor notes and the doctor's testimony. Nonetheless, the plaintiff is entitled to recover for those sorts of injuries. In those particular cases, great weight is placed on the prior medical records, and in those cases, of course, you certainly need a lawyer, as almost with any automobile accident or injury case, particularly if serious injuries involved. If we can help with this or any other matter, please feel free to call us at 843-317-4900, 317-4900, or you can reach me by email at gfinkley@finkleylaw.com, or you can send us a message through our website at finkleylaw.com. Thank you very much and have a great day.